Hey, Gene, just want to make sure we have everything working. Can you hear me?
I can. Can you hear
Okay.
me?
Yep. Okay, we're good there. Okay, I just want to make sure we'll give it another 5 minutes or so, and then we'll go ahead and start.
Okay, good. I'm going to turn off the light over my head.
Have everything working.
So are you from Salt Lake or that area, or where are you from?
So I'm from Arizona, down
Oh,
south, basically, Sierra Vista, Arizona. It's like 30, 40 minutes from the border. So yeah, I'm
okay.
I'm
Or
way
the
down
Utah
there.
border or the Mexico border?
What was that?
The Utah border or the Mexico border?
Mexico border. Yeah,
Oh,
like
wow.
it's the last big town before you hit Mexico. So it's
Uh-huh.
yeah, it's it's a small little town. It's a military town. But yeah, that's where that's where I grew up pretty much. Are you currently in Washington or are you in, because I know you're a adjunct faculty teacher. I meant to
Right.
ask.
Yeah, I'm at my home in DC, in the
Okay.
DC area, and I've been teaching from here since March when the pandemic hit, but I'm told that I'm supposed to go back and teach on campus in January. So
Oh,
we'll
okay.
see how that works out.
Yeah.
Do you are your classes on campus or are they all online?
We're doing online pretty much the majority of the classes as well. It's pretty similar to
Hmm.
BYU.
Yeah.
Um, and then next semester they've, pretty much doing the same thing from what I can tell. So
Hmm.
yeah, it's kind of craziness right now. So we'll see what happens. Just everyone's kind of dealing with it as they go.
Yeah. Yeah. Are there you all have a 3 semester system, is that right? Or do they don't do that anymore?
What is the 3 semester system?
Well, when I was at BYU, people at the U were on and I didn't go to law school there. I went to BYU as an undergrad, but
Hmm.
I know friends of mine at the U were on a 3 semester system of some kind where they would start like in mid to late September, and then they would have their second semester that started right after the holidays, and then they would have a third semester that like started around March or something and went through June.
Yeah, that sounds terrible. We don't we don't have that anymore.
No,
We
no,
just
that's
yeah, we
good.
follow the 2 track system, and then you can do summer classes as well if you're interested. But yeah, that sounds not as accommodating as it is now. So yeah,
No,
we
it,
follow.
it you know it meant all the BYU students got the jump on the U people for summer jobs.
Exactly. Yeah,
Did you go there as an undergrad too, or
I did. Yeah, I
okay?
went there as undergrad, and then I traded sides.
You
Got to
traded sides?
got to experience both sides of the battlefield.
Oh, so where did you go as an undergrad?
BYU. I went
Oh,
there.
BYU. Okay.
Yeah, exactly.
Oh,
Yeah. So
oh, good.
I've seen both sides now.
Yeah, yeah. I made a similar choice for law school. I thought it would be, thought it'd be good to see a different atmosphere and a different experience, and it was instructive.
For sure. And I've got to be real careful what I say because I know there's a few of our faculty and the attendees. So the
Uh-huh.
U has been the greatest experience I've ever had. But no, it's been great.
Yeah.
So it looks like we're getting pretty close to where we're going to be. Are you going to be sharing any slides or anything?
Yes.
Okay.
Yeah. And I assume I can just do that normally.
Yeah, you should be able to do that just through the share screen. I assume
Okay.
you've probably been on Zoom for the last little while, like everyone
Yeah.
else too, so you
Yeah.
know
I've
how to do
become
it.
more of an expert than I would like to be, but
Exactly. Okay, so give me another minute. I'll be right back. I'm just gonna make sure my daughters are okay real quick before we start, and then by
okay.
the time I get back, I think we'll be pretty much ready to go.
All right. Sounds good.
Okay. So it's about 12:15 now, so I think we'll go ahead and get started. Well, I'm sure we're going to have some more trickle in as we go. But anyways, we just want to thank everyone for coming to this webinar that we have. We're thankful for Mr. Shar, who's come and offered to give us a little bit of an intro on our newest Supreme Court Justice and what that's going to look like for us going forward. We want to thank BYU for co-hosting this event with us. It's always great to reach across the aisle, as you would say, and to work with some of our more competitive schools. Just a reminder, we'll have about a 45-minute lecture from Mr. Shar, and then at the end, we will have a little bit of time for questions. So if you have any questions, you can let us know in the Q&A section at the bottom or the chat, and then we can ask them that at the end. I'm just going to read a little bit of a bio about Mr. Shar. Before we start, he specializes in handling civil appeals, writ proceedings, and similar matters, both in appellate courts and in the kind of law-focused proceedings at the trial court or agency level that often determine success or failure on appeal. He's argued and won dozens of cases in a variety of forums, including the U.S. Supreme Court, where he's argued 7 cases, every federal district, and numerous federal district courts and state appellate courts. His win rate in the dozens, win rate in the dozens of federal appeals he has argued in the past several years is over 75%. He was a coordinator of Sidley Austin's appellate practice firm from 1993 until 2005, and from 2005 until 2014, he was the chair of the nationwide Supreme Court and appellate practice at Winston and Strawn, a practice he led to numerous recognitions in such publications as the Appellate Hot List. His personal practice successes have won him repeated recognitions in such publications as the Best Lawyers in Washington, D.C., Legal 500, D.C. Super Lawyers, and Best Lawyers in America. In January 2014, Mr. Shar formed his own boutique litigation firm so that he could serve his clients without the conflicts and inefficiencies inherent in big law firm practice. He also teaches courses in Supreme Court litigation, religious freedom litigation, constitutional law, and advanced litigation skills as an adjunct professor at BYU. He began law practice in 1987, following clerkships on the U.S. Supreme Court for Chief Justice Warren Burger and Justice Antonin Scalia, and then on the U.S. Court of Appeals for the D.C. Circuit for then Judge Kenneth Starr. He graduated in 1985 from the Yale Law School, where he was editor-in-chief of the Yale Journal on Regulation and senior editor of the Yale Law Journal. From 1991 to 1993, he served in the White House as associate counsel to the president, where he had responsibility for a wide range of constitutional administrative law issues, including those involving economic regulation, higher education, separation of powers, federalism, and religious freedom. So it's a brief intro to our great speaker that's come today, and he has a personal connection, from what I understand, with Justice Barrett as well. So we look forward to hearing from you. Why don't you go ahead and see if you can start sharing your screen?
Okay, it's not letting me yet. I guess you have to allow.
Oh, sorry, I accidentally muted you.
Okay.
I will make you host. And now you should be able to do it.
Okay, good. Now let me see if I can get the right screen shared here. Actually, before I do that, let me just tell you all what a pleasure it is to be with you today. And for those of you at BYU Law School, I look forward to returning and being with you in person next semester. I was happy to get the news that my 2 courses would be taught in person next semester. As has been mentioned, I've gotten to know Justice Barrett pretty well over the last 25 years or so, mostly from seeing her and her husband at Justice Scalia's annual clerk reunions. She and I both clerked for him. I had the privilege of clerking for him during his very first term as a justice on the Supreme Court, back when he didn't know what he thought about everything in the law. And but Justice Barrett and I have also interacted on some law school related issues during the years since we both clerked. And of course, I hope all of you had an opportunity to watch her confirmation hearings for 3 days. They were a wonderful window into her judicial soul. And that's what we're going to talk about today, and specifically her likely impact on 6 important areas of constitutional law. Did the sharing work? Can you see my screen?
Yes, we can see. It looks good.
Okay, good. So here's a picture of her, obviously, during the little ceremony at the White House, also known as the Super Spreader event, where her nomination to the Supreme Court was announced. And but to understand her likely impact on First Amendment and religious liberty issues, which is where we'll start, it's necessary to assess or at least review the views of her predecessor, Justice Ginsburg, who's pictured here with her fellow justices as the court was configured when she passed away. And I'll just say, by way of a little detour, that Justice Ginsburg, in my view, was, although I disagreed with her on a lot of important issues, she was a very admirable judge and ultimately justice. And in fact, during my clerkship with Justice Scalia, I was at first a little surprised at his admiration for her. I well remember once when he invited me to go running with him, which was a favorite pastime of his, especially during the summer and fall months in Washington. And I think he liked me to go running with him because my company made him think that he was in better physical condition than he really was. But during one of those runs, I asked him a hypothetical question. If the next president of the U.S. were a Democrat and he told you he would nominate any judge in America to the Supreme Court with the stipulation that it had to be somebody who had been appointed by another Democratic president, whom would you recommend or whom would you choose? And without missing a beat, he barked, Ruth Ginsburg. And I pressed him a little bit, especially given their ideological differences. And he said that the reason he would recommend her is because in the vast majority of cases, he said she's a real judge, which for him was about the highest praise he could give to a judge. It was somebody who, it denoted somebody who honestly tries to apply the law rather than deciding on his or her desired outcome and then working backward from that result. And apparently, he later had that very same question or that very same conversation with President Bill Clinton. And apparently that was part of the reason that Bill Clinton appointed her to the court. And I think part of his motivation in seeking Justice Scalia's views was he wanted to try to grease the skids for her with the Senate. And he knew that if she had Justice Scalia's recommendation, that would make it easier to get her confirmed. So, and here's a picture of yours truly with Justice Scalia. We both look exhausted, and perhaps the reason for that is that we may well have been up all night when that photo was taken. When I clerked for him, the Supreme Court decided about 3 times as many cases as they do now. So it was it was a much more demanding job than it is now. But as you can see from this slide, Justice Ginsburg, despite all of my admiration for her on a lot of issues, she was really no friend of religious liberty. And this is a chart that shows the voting patterns of all the justices beginning in 1991, when Justice Thomas went on the court through this year. And like Justice Sotomayor, she voted for religious freedom claimants in only about a quarter of the cases that raised those issues. And in that regard, she stands as a bit of a contrast to the other 2 Democratic appointees, Justice Breyer and Justice Kagan, who have voted for the religious freedom claimant more than half the time in the religious liberty cases that they've sat on. And if we go to the next slide, which focuses on religious liberty claims in which the countervailing value, if you will, is some aspect of the sexual revolution, whether it's abortion or contraception or LGBT rights or anything like that. We can see here that in fact Justice Ginsburg never voted in favor of the religious liberty claimant in those situations, even though the other Democratic or two of the other Democratic appointees did a fair percentage of the time. So she was in her day. She was probably the least friendly to religious liberty claims of any justice on the court. And right up there with Justice Sotomayor, who I think is going to carry her torch. So, why do I think that Justice Barrett will be more favorable towards religious liberty than Justice Ginsburg was? One reason is that it would be difficult to be less favorable. But there are a couple of other reasons. First, she embraces Justice Scalia's textualist, originalist judicial philosophy, and except for one major and famous case, his most famous religious liberty case, known as Employment Division versus Smith, Justice Scalia generally voted in favor of religious liberty claims while he was on the court. In fact, it was about 88% of them, and so when Justice Barrett said that Justice Scalia's philosophy of judging was her philosophy, which she said several times, both before and after her nomination and during her hearings, that's a pretty good indication that she is likely to be generally as friendly towards religious liberty claims as Justice Scalia was. But another reason to believe that she's likely to be fairly favorable to those kinds of claims is that she was in fact favorable to those claims as a Seventh Circuit judge. There are two significant cases in which she was a member of a panel. One was a ministerial exemption case involving a Jewish day school, and she joined an opinion holding that a teacher at that Jewish day school fell within the ministerial exception to the civil rights laws, and therefore that she could not assert civil rights claims against the school that she worked for. Another very interesting case in which she was on the panel was a fairly recent COVID-related case in which the claim was brought by the Illinois Republican Party that Governor Pritzker's COVID order was treating political parties less favorably than religious bodies. And in an opinion by Judge Diane Wood, who was appointed by, I think, Bill Clinton, but joined by now Justice Barrett, the Seventh Circuit ruled that kind of a disparity was okay because the Constitution itself carves out room for religious activities that the Constitution does not carve out for other kinds of activities. We're going to get an opportunity this term in a case called Fulton versus Philadelphia, which some of you have probably been following. But the question in that case is whether the First Amendment prohibits the government from conditioning various kinds of government assistance, like licenses and funding, on religious institutions being willing to abandon their core religious beliefs when those beliefs run up against a policy of the government at issue. In this case, it was a pro-LGBT policy, just based on the oral arguments and what I know of her general philosophy, I think Justice Barrett is likely to join with Justice Alito and others on the court in holding, and I think there will be a majority for this, that in fact the city of Philadelphia cannot condition Catholic social services participation in the city's foster care program on their willingness to forego or to abandon, in some circumstances, their beliefs about marriage and the importance of children being raised by a father and a mother. One of the questions, though, that's presented expressly in the Fulton case is whether the Supreme Court should overrule Employment Division versus Smith, which I mentioned earlier, and which was the decision that Justice Scalia wrote, holding that as long as a law is neutral and generally applicable, it is not subject to strict scrutiny as against a free exercise claim. There have been a lot of people hoping that the new Supreme Court, with the newly configured Supreme Court, will overrule that decision. I personally think Justice Scalia had decided by the end of his life that decision had been a mistake. But at the same time, I doubt that there will be a majority to overrule that decision in the Fulton case, because there are other narrower ways that the court can rule in favor of Catholic social services there without overruling Smith. And my guess is that in general, Justice Barrett is going to be a little bit like the Chief Justice in deciding how quickly to move the law. As you probably know, there are justices like Justice Thomas who feel like if a precedent of the court was wrong, we ought to just overrule it and be done with it. But Chief Justice Roberts is much more of an incrementalist, in the sense that he doesn't want to overrule past precedents, even if he vehemently disagrees with them, unless it's necessary, because he believes that that kind of not willy-nilly, but he believes that frequent stark overruling of prior court decisions have the effect of reducing the public's respect for the court, and so he's much more reluctant to do that. I think Justice Barrett is likely to be a bit more of an incrementalist on those kinds of issues than Justice Thomas, for example. Well, there's an important tactical question that people who advocate for religious liberty have to decide with regard to Justice Barrett, and that is that, given the view, which is pretty widespread, that she's likely to be pretty friendly to religious liberty claims, does that mean that advocates of religious liberty can just sit back and count on the Supreme Court to protect religious freedoms when those freedoms run up against other social policies, whether it's COVID or abortion rights or LGBT rights or anything like that? And in fact, I think the answer to that is no. And there's an interesting pattern in the Supreme Court's religious liberty cases, which is captured by this slide, and that is that if you look at cases since 1987 involving religious liberty claims, you can see from the bar on the left that the Supreme Court has ruled in favor of the religious liberty claimant in 75% of those cases. But if you focus just on the cases that involve constitutional claims, generally under the First Amendment, the win percentage for religious liberty was only 58%. And by contrast, if you look at cases where the court had a statute that they could rely on to rule in favor of the religious liberty claimant, cases like Hobby Lobby, the win rate for the religious liberty claim is much higher. It's at 92%. And then if you further subdivide the cases and look just at those involving sex-related cases, the win rate for religious liberty claims in all of those cases is an average of 80%, but the win rate involved where the claim is just a constitutional claim is only 50%. And the win rate in cases that involve statutory claims is 100%, 3 out of 3. Again, my guess is that Justice Barrett is going to be another advocate or another protector of religious liberty on the court. But it's important when one has an opportunity to try to persuade a legislature to adopt a religious exemption to a law that might otherwise burden religious practice in some way. It's important to still try very hard to get that religious exemption, because the risk of not being able to prevail in asserting a claim of religious liberty goes way up if you're relying solely on the Constitution and don't have a statute to rely on. And for those of you who are at BYU, if you're interested in this topic, feel free to sign up for my religious liberty litigation course next semester, and we'll spend an entire semester studying these things, and we'll have an opportunity to talk about Fulton, which I suspect may come down during the semester, and a number of other interesting religious liberty cases that we're going to see coming out of the Supreme Court, including a cert petition that I have pending that I hope the court will grant. So let's move on from the First Amendment to the Second Amendment. And obviously, as we did with religious liberty, if we want to assess the likely impact of Justice Barrett on Second Amendment law, it's helpful to begin by asking, well, how did the justice that she replaced do on Second Amendment issues? And those of you who have followed the Second Amendment area in the Supreme Court are probably aware that Justice Ginsburg was not a fan of Second Amendment rights. She voted in favor of the firearms restriction that was at issue in the Heller case, of course, which is the Supreme Court's major Second Amendment case of the last couple of decades, and of course Justice Scalia wrote the opinion for 5 justices invalidating the DC gun law that was at issue in that case. So, you know, my view is that Justice Barrett is going to be more in the mold of Justice Scalia when it comes to Second Amendment issues, not only because she said that his philosophy is her philosophy, but also because as a Seventh Circuit judge, she had one case involving a Second Amendment issue, a case called Cantor versus Barr, in which, in dissent, she wrote that the text and history of the Second Amendment protect an individual right to bear arms that cannot be stripped even from nonviolent felons. And that was the issue in that case, is whether the state can strip Second Amendment rights from people who have been convicted of nonviolent felonies. And she said, no, I don't think the state can do that consistent with the Second Amendment. And she, in her analysis, she also relied very heavily not just on the text of the Second Amendment, but on founding era sources to try to determine what the right answer to that question was. So I think she's likely to be a strong defender of Second Amendment rights, and this could be quite important at the court, because even though Chief Justice Roberts and, of course, Alito and Thomas voted with Justice Scalia in Hellerstedt, at least one member of that 5-4 coalition has been very reluctant to grant any more cases that assert a violation of Second Amendment rights. And there's some suspicion that it's the Chief Justice who just doesn't want to see the court get into the business of evaluating gun regulations. But Justice Barrett's presence on the court could well provide the fourth vote I think there are 3 votes on the court right now who would like to see the court take up more Second Amendment claims, and Justice Barrett could well provide the 4th vote to do that, even though the Chief Justice is apparently opposed to the court getting very, very heavily involved in Second Amendment issues. So her influence could be felt in that area, mostly in the cases that the court decides to grant rather than deny. Moving on then, we've dealt with the First and Second Amendment. We'll move on to the Fourth Amendment. And again, it's useful to compare, or useful to begin this discussion with a brief analysis or summary of Justice Ginsburg's views on Fourth Amendment issues. And in fact, this is one of the areas where she and Justice Scalia were real allies on the court. In fact, I'll tell you just a very brief story that sort of captures Justice Scalia's view. The very first opinion that he asked me to draft for him when I was his law clerk was in a case called Arizona versus, now the name of it is escaping me, but you Fourth Amendment mavens will remember it. It was the case that involved, or Arizona versus Hicks was the name of it. And it involved the plain view exception to the Fourth Amendment. You may recall that. And there were some conservative justices on the court at the time, Chief Justice Rehnquist and Justice O'Connor, who really kind of wanted to expand the plain view exception to the Fourth Amendment warrant requirement. And so this case came up involving a police officer who had legitimate reasons to enter somebody's apartment. And I can't remember even what those legitimate reasons were, but in the course of this lawful search of this person's apartment, this police officer saw some expensive stereo equipment sitting on a table in the apartment. And he thought, well, this is kind of odd that this low-life guy that I've been pursuing here has this expensive stereo equipment in his apartment. I wonder if it's been stolen. So he went over and he picked up the stereo equipment and kind of turned it over and got the serial number for the equipment off of the bottom of the equipment. And so even though the stereo equipment was in plain view, the serial number that proved to be key in determining that yes, that equipment had in fact been stolen, that number was not in plain view. And so the question before the Supreme Court was whether that search falls within the plain view exception to the warrant requirement, and the court was split 4-4 on it. The more liberal justices all thought that should not be within the plain view doctrine, and the more conservative justices all thought that it should be, and Justice Scalia was in the middle. And this was the very first opinion that he had written for the court. And so the court at conference, the vote was 5-4. Justice Scalia sided with the 4 liberal justices to say, no, this does not really fit within the plain view requirement, because the key element that resulted from this search was not in plain view. It required turning the stereo equipment over. And so he voted with the liberal justices, and sure enough, Justice Brennan, who was the senior justice in the majority, decided to assign the opinion to Justice Scalia. So I wrote the draft of the opinion, and he reworked it as he was wont to do. And then the court issued the opinion, still 5-4. We didn't persuade anybody else to join us. And the day after that opinion came out, there was an editorial in the Wall Street Journal publicly wondering whether President Reagan had made a mistake in putting Justice Scalia on the court, and expressing concern that he was going to end up turning into a liberal, just like Justice Brennan had, and other Republican appointees. Their fears, needless to say, proved unfounded. But on Fourth Amendment issues, his textualism led him to be pretty strict about enforcing Fourth Amendment rights. And so he, once Justice Ginsburg got on the court, the two of them, were very frequent allies in Fourth Amendment cases. So the question is, where do we think Justice Barrett will end up on those issues? Well, again, she is a textualist and an originalist, and you would think that would lead her to be, to be more serious about enforcing Fourth Amendment rights than some of her colleagues. For example, Justice Alito, who takes a somewhat laxer approach to Fourth Amendment rights. But besides that, Justice Barrett, as a Seventh Circuit judge, has defended Fourth Amendment rights in a couple of cases, one of which was called Rainsberger versus Benner, in which she criticized an affidavit written in support of a warrant application. Because she thought on its face it was riddled with lies, and she said that kind of an affidavit can't support a warrant. And then another case called U.S. versus Terry, she ruled that it was unreasonable for police officers to assume that a woman who answers the door in a bathrobe has authority to consent to a search of a male suspect's residence. That's a case that a lot of conservative judges or a lot of Republican appointees would probably have said, yeah, that's, the Fourth Amendment is no barrier to either of those searches, but she voted to vindicate the Fourth Amendment rights of the defendants in those cases. And then during her confirmation hearings, she articulated a broad originalist understanding of the Fourth Amendment that is very consistent with the views of both Justice Scalia and Justice Ginsburg. She said that the Fourth Amendment enshrines a principle that protects against unreasonable searches and seizures, but it doesn't catalog the instances in which an unreasonable search or seizure could take place. And so, that suggests that she would take the same kind of approach that Justice Scalia took, for example, in the famous case that involved a search using infrared technology from a helicopter, where Justice Scalia sided, voting with the more liberal justices on the court, voted to say that, yeah, that is in fact a search for Fourth Amendment purposes, and you've either got to have a warrant or one of the well-established exceptions has to apply. Now, there's an interesting Fourth Amendment case before the court this term called Lang versus California, which also deals with the exigent circumstances exception to the warrant requirement. And the specific question is whether that exception allows police to enter a home if they have probable cause to believe a person has merely committed a misdemeanor. And if you're not familiar with with that case, it's really kind of it's a funny case. It involves a guy who was followed by the police, and I think they suspected that he was, that he had been drinking alcohol, but they couldn't tell for sure based on how he was driving, and so but he was playing his radio very loud, which is a misdemeanor in that city, a misdemeanor punishable by a fine of like $75. So on that basis, the police officer followed this guy home, and the guy put his car in his garage, and as he was closing his garage door, the police officer stepped into his garage and told him he needed to do a search of the car, and in the process of doing a search of the car, I think concluded that he had been drinking or something. So, but the justification for that entry into a home without a warrant was this, potential $75 misdemeanor conviction. So it'll be interesting to see how Justice Barrett and the other justices vote in that case. But again, my guess is that Justice Barrett is going to be on the side of protecting the Fourth Amendment as originally understood and written. Well, let's move on to another important amendment, the 14th Amendment, and obviously one of the most important issues there that has come up in the past in the Supreme Court is what to do about affirmative action, and especially quotas. Is an affirmative action program or a quota system that discriminates against white male Caucasians in favor of other groups? Is that a violation of the 14th Amendment or a violation of statutes that were passed under the authority of the 14th Amendment? And you may recall that in the last case involving affirmative action, parents involved versus the Seattle School District, there was a good deal of sentiment to say that no, discrimination against white male Caucasians is prohibited by the 14th Amendment and by the relevant statutes, just like discriminations against blacks or women. And the way to stop discrimination on the basis of race, the Chief Justice said, is to stop discriminating on the basis of race. And I'm sorry, that case did not directly involve affirmative action, but the last case that did was Fisher versus University of Texas, in which a 4-3 majority of the court upheld the University of Texas's affirmative action policy. And the reason it was 4-3 is that Justice Scalia had passed away while the case was pending, and Justice Kagan was recused. And Justices Kennedy and Ginsburg were in the majority, but of course they're no longer on the court. And the three that have since joined the court, Justice Gorsuch, Kavanaugh, and now Justice Barrett, I think are likely to share the views of the three dissenters in the Fisher case. And so we may well see a change on affirmative action in the Supreme Court. And there's a case that is headed to the Supreme Court right now. Some of you may have noticed that this morning the First Circuit issued a decision in the Harvard race-conscious admissions case, holding that Harvard's race-conscious policies do not violate Title VI of the Civil Rights Act, which was, of course, passed under the authority of the 14th Amendment. I know the lawyers who are handling that case on the plaintiff side very well, and I'm quite confident that they plan to challenge that ruling in the Supreme Court. And although that case doesn't actually ask the question under the 14th Amendment, I suspect that the way the justices answer the statutory question will likely give us a preview of their answer to the constitutional question. So stay tuned on that one. Another important area of constitutional law where Justice Barrett could well have a significant impact is on the separation of powers, and one of the issues that's important to a proper understanding and application of the founder's vision for separation of powers involves questions of severability. And for those of you who watched Justice Barrett's hearings, you no doubt saw that there were lots and lots of questions about the Affordable Care Act, and which of course was just argued just this week. And of course, the Democratic opponents of her confirmation did their very best to try to predict that Donald Trump had put her on the Supreme Court precisely so that she could vote with the other Republican appointees to invalidate the ACA. Well, I know there are Republicans who think that might happen, but I've always thought it was a pipe dream. And frankly, it's probably the most proximate reason why Donald Trump lost the election, as I think he has. He might be able to pull a rabbit out of a hat with his challenges to the votes in various states, but it's going to be a very uphill climb. But I think if the administration had not given the Biden campaign that really powerful talking point that, look, Donald Trump is trying to kill the ACA, and in so doing is trying to take away protection for pre-existing conditions and trying to take away the ability of people your age to get to be insured under their parents' insurance policies up until age 26. And my children benefited from that. It was a very powerful talking point for the Biden campaign. And it was, to my mind, it was completely senseless because I never thought there was any realistic shot, even if the court decides that the individual mandate is unconstitutional. now that the tax associated with it has been eliminated, I have never thought that a majority of the Supreme Court would decide on that basis that the entire ACA has to be abolished and is somehow invalid. So I think it's unfortunate that the Trump administration may well, and certainly unfortunate from their standpoint, that they may have, as it turns out, they may have given up a win in the presidential election in order to pursue a legal theory that never really had any significant chance of success in the Supreme Court. So, and back to Justice Barrett, you may recall that she had an exchange with Senator Feinberg about the severability doctrine and what it means, and she had a great analogy to a Jenga game, which I had never heard before. Some of you may have some, you may have creative professors in your con law classes, but I'd never heard that analogy before. I thought it was quite effective, but it also conveyed quite clearly, I think, that she's very unlikely to vote to dismantle the entire ACA based on the individual mandate. So let's, if we can, let's just listen for a moment. Sorry, let's just. Hope I haven't screwed this up. Let's just listen to a couple of minutes of this testimony.
Like a Jenga game, it's kind of if you pull one out and you pull it out while it all stands, or if you pull two out, will it still stand? So Justice Scalia, his view was that if you pulled those two provisions out, could it still stand? And here we're talking about one, and also Congress has amended the statute since NFIB versus Sebelius, and it zeroed out the mandate. So now, California versus Texas involves a different provision because of the zeroing out that was done by amendment. So that's how the two cases present slightly different issues.
What do you think of all that?
What do I think of severability? Or
in that instance?
I think the doctrine of severability, as it's been described by the court, serves a valuable function of trying not to undo your work when you wouldn't want a court to undo your work. Severability strives to look at a statute as a whole and say, would Congress have considered this provision so vital that kind of in the Jenga game, pulling it out, Congress wouldn't want the statute anymore. So it's designed to effectuate your intent. But severability is designed to say, well, would Congress still want the statute to stand even with this provision gone? Would Congress have still passed the same statute without it? So I think insofar as it tries to effectuate what Congress would have wanted, it's the court and Congress working hand in hand.
Thank you. That's quite a definition. I'm really impressed. Thank you.
And that was just a brilliant moment, I think, in her confirmation hearing. But one thing it illustrates, I think, is this may be an area where Justice Barrett might be a little more deferential to Congress than Justice Scalia was. As you remember, Justice Scalia thought that the invalidity of the individual mandate, was combined with the problems with the Medicaid provision in the ACA, he thought that was enough to invalidate the whole law. Whereas, of course, the Chief Justice worked very hard. Some might say even not entirely honestly. He worked very hard to try to uphold the statute, by redefining the penalty as a tax and that sort of thing. And but just based on her answer there, you sense a greater deference for Congress than you might have seen with Justice Scalia and some of the other justices on the court. So that'll be an interesting area to watch. Again, Justice Ginsburg was she was in the minority in NFIB versus Sebelius. She didn't in fact and she voted with the Chief Justice's opinion to uphold the ACA and to hold that the individual mandate was a tax and a legitimate tax. Final area is also an important structural issue in our constitutional system, and that is federalism. And of course the most prominent issue of federalism or respect for state prerogatives in constitutional litigation today, of course, concerns abortion. How much authority do states have to regulate the abortion decision, either regulate the decision by women or regulate the medical providers who provide abortion, and of course federalism was ultimately at issue in Obergefell and a lot of other cases that I sometimes refer to as sexual revolution cases. Well, as those who have followed Justice Ginsburg's career on the court, you will know that she was not very deferential to state prerogatives in those situations. She thought that there was a clear, she thought that there was a constitutional right to an abortion, or at least she was willing to enforce and maintain Roe versus Wade. And in the same-sex marriage case, she voted with Justice Kennedy to conclude that one could discern in the 14th Amendment a right of same-sex couples to marry each other on the same terms as opposite-sex couples. So it'll be interesting to see how Justice Barrett deals with those issues. And of course, besides the ACA, a lot of people who were concerned about her nomination to the court were and remain, I think, quite concerned about what she will do on the abortion front. And in fact, she, as a Seventh Circuit judge, she joined two dissenting opinions that addressed abortion. Nothing that sort of goes to the heart of Roe versus Wade or anything, but one of those cases, Planned Parenthood versus Commissioner. In that case, she would have upheld a ban on abortions because of the sex or disability of the fetus. And this law also required fetal remains to be buried or cremated. She was in dissent in that case, and the Supreme Court did not take that case up. And the second case, called Planned Parenthood versus Box, she also voted to allow a parental consent requirement. And she lost that battle in the Seventh Circuit as well. But so obviously, in determining how she's going to rule on abortion-related cases, we really have to examine her likely views on stare decisis, because as we all know, there is at least one justice on the court, Justice Thomas, who has said that he thinks the court ought to overrule Roe versus Wade and the entire line of authority based on Roe versus Wade, simply because, in his view, it was wrong as a matter of first principles. And I share his view on that, and my guess is that Justice Barrett does, and probably every justice on the Supreme Court shares that view, that it was that Roe versus Wade did not really embody a fair interpretation of the constitutional text. But the question, of course, for everyone on the court is, what do we do with this precedent that has now been on the books for such a long time? Justice Barrett's academic writings would suggest that she's, that she is probably not at the Thomas end of the court, but at the same time, she is probably more willing to reconsider and to revisit and overrule past precedent than some of the justices are. You can see these quotes from her academic writings. The last one says, "An argument that the precedent was wrong is not enough to justify an overruling." That was actually not from an academic writing, but a response to a question from Senator Graham during her confirmation hearings. That is a clear indication that she disagrees with Justice Thomas's position, because he would have answered yes to that question, or almost yes. And in her academic writing, she's acknowledged that it's important to consider the impact of overruling a precedent, and that the preclusive effect of precedent, kind of on the other side, raises due process concerns. If a precedent is going to foreclose a particular claim, doesn't that interfere with the claimant's due process rights? So I don't think we have enough from her academic writings to be able to draw a firm conclusion as to where she's going to come down on cases like Casey and Roe versus Wade in the abortion context. My guess is, though, as I said before, that she will be more inclined to be an incrementalist in dealing with those issues, and less inclined to just kind of throw everything out in one fell swoop. There's a case on the Supreme Court's docket this term, Dobbs versus Jackson Women's Health, that is going to give us an opportunity to perhaps see more of her thinking on abortion and stare decisis. The Dobbs case involves, as you can see from the slide, a Mississippi law that bans abortion after 15 weeks, and asks whether all pre-viability prohibitions on elective abortions are unconstitutional. And so it's a pretty direct challenge to Roe versus Wade in that regard. And the court hasn't yet granted cert in that case, but the case has been rescheduled repeatedly since September, suggesting that either the court is seriously considering granting that case, or it could also mean that one of the more conservative justices is writing a dissent from the denial of cert and just hasn't finished it yet. But I think since she's on the court now, she's going to have an opportunity to vote on whether to grant cert in that case. And at a minimum, it's a case that if the court granted it, it could narrow the reach of the Casey decision. But as I said, I think Justice Barrett is unlikely to overrule either Casey or Roe, at least not anytime soon. I'll just sum up by noting that Justice Barrett is not the only justice on the court who claims to be a disciple of Justice Scalia. Justice Gorsuch, after in the wake of Justice Scalia's death, had wrote some very nice things about him, suggesting that he liked Justice Scalia's judicial philosophy. I will tell you that after he was confirmed, he actually was the host for the Scalia reunion that year, which occurred just a couple of months after he was confirmed, and he was quite unguarded in his remarks. He said, and you can see from the picture that he and Justice Scalia had been fishing together in Colorado, and he knew that Justice Scalia had an elk head hanging in his chambers that he had shot on another hunting trip to Colorado, and Justice Gorsuch told the court that he really wanted to have Justice Scalia's chambers if he could, and he started to move in and noticed that elk head was no longer hanging on the wall, and it turned out that somebody had boxed up that elk head and had shipped it off to one of his former clerks who had taken him on that hunting trip where they had shot the elk together. And so it was sitting in a box in this guy's garage in Colorado. So Justice Gorsuch found out who it was and called him up and said, "Hey, I'd really like that LKED back, if you don't mind. And I'm going to put it above my desk in my chambers, right where Justice Scalia had it." And so he told us at the clerks reunion that one of the reasons he wanted to have that LKED there was because it would remind him that Justice Scalia would be looking down on him and evaluating whether he had done a good job of picking up and carrying Justice Scalia's mantle. So you all may recall, you may be too young for this, but several years ago, there was an ad for an online banking service that I think Lending Tree or something like that. And the ad said, "When banks compete, you win." Well, it'll be interesting to see if we have that dynamic at work here between Justice Barrett and Justice Gorsuch, competing to see who can be the most Scalia-like in their approach to their work. And especially if the two of them genuinely try to do that, I believe we'll see the law in all 6 of these areas move in a more textualist direction. And I look forward to your questions.
Awesome. Thank you so much. That was great. A great insight into what's potentially going to happen here in the next couple of years with this conservative swing in the court. So if you do have, looks like we have time for like 1 or 2 questions. We have one so far, but you can either type it in the Q&A or the chat. We can start with this one question, and if we have any more, we can probably adjust one more. This one's from Luke Hansen. He says, "Thank you again for taking time out of your day to present to us. Your presentation was very enlightening. Do you believe Justice Amy Coney Barrett will recuse herself if SCOTUS takes up pending 2020 presidential election litigation?"
No, and it would be silly for her to do that. No justice that I'm aware of has ever recused himself or herself from a case simply because the president who appointed them has an interest in the outcome of the case. Now, if she had actually worked on the litigation as a Seventh Circuit judge or worked on some prior version of the litigation when she was in private practice, that would be a basis for recusal. But there's no basis for a justice to recuse himself or herself just because the president who appointed them has a strong interest in the case at hand.
Great. Let's see, we have one more question here we have time to address. Came in from the chat. Oh, never mind. It's just Luke saying, "Glad to hear it. Thank you." So give it another minute if anyone else has any other questions. I know it takes a second to type it in.
While we're waiting for questions, I have to say that I am just, as a BYU and Utah fan, I'm just sick that the 2 schools are not going to be able to play each other in football this year.
I know, it's very true, because it actually this year probably would have been a little bit more competitive. They've been good games, but yeah.
Yeah, they have. I never underestimate Kyle Whittingham.
There you go. It's true. All right, well, it doesn't look like we're going to have any more questions. So on behalf of the BYU chapter and the University of Utah chapter, we just want to say thank you so much for taking the time to create that wonderful presentation for us. It was a great insight, and I guess we'll just wait and see how great of a prophet you were in those in those opinions. But yeah, we appreciate your time. Thank you so much for everyone for coming, and we look forward to having more events in the future with BYU.
And it's a pleasure to be with all of you, even though I can't see any of you.
That's true. All right. Thank you all for coming, and thank you again.